Joining me now is Dahlia Lithwick, senior editor for Slate, host of the Amicus podcast, and author of the New York Times best-selling book, Lady Justice. Jeff Rosen is the president and CEO of the National Constitution Center, professor at George Washington Law School, and contributing editor at The Atlantic. Good morning to both of you. Great to see you. Thank you for being with us. Dahlia, I will say, I think it may come as a surprise to a lot of people, or has come as a surprise to a lot of people, that there isn't actually a code of ethics that governs the Supreme Court. I think we know that there aren't a ton of rules around the Supreme Court, including a rule as to when you need to retire. But you wrote the other day that the fact that some of the justices believe that casual and social relationships with lobbyists, activists, and interested parties who have business before the court are appropriate and acceptable is the problem, because it means they cannot be trusted to avoid such contacts. Seems obvious what you wrote. What is the proposed solution to this?
Well, I think you're right that there's no code of ethics, but there also is one, because there is a code of ethics that applies to all Article 3 judges, all federal judges. It's just that it's not binding on the Supreme Court. So they consult it. That's the word that the Chief Justice used. But they're not able to enforce it against one another, and they certainly don't appear to be enforcing it as against themselves. So I think that this goes to this kind of cardinal, ancient principle: no man should be a judge in his own case. They are left to police themselves, and they, I think, do it by way of feelings ball. And if they feel like it's okay for them to fly out with donors and, have dinners at their mansions or at their clubs, and they think it's okay to pray with people who have interest before the court, then that's where the kind of inquiry stops. I think the solution is to make some version of the canons and codes binding on them and have a way to enforce it.
Jeff, what's your take on that?
I agree. The bipartisan commission that President Biden set up also recommended that the court adopt a rule of ethics. And it noted the difficulties that the courts have gotten themselves into by allowing themselves to escape abiding by the ethics codes voluntarily. There is an interesting constitutional question about whether Congress could force the court to adopt an ethics code. There's a bill pending in Congress. It might pass, but Chief Justice Roberts has suggested that Congress has the power to create the judicial conference, which binds the lower courts. But because the Supreme Court is independently set up by the Constitution, Congress can't force it to obey ethics if it doesn't want to. We also saw during the sexual harassment scandal that the court, under pressure, adopted sexual harassment standards for the entire judiciary, maybe less strict than Congress would have adopted. But it just confirms Dahlia's basic point that the court has total discretion to act as it will. And I think the bottom line here is that at a time when the court's legitimacy is under serious question, in light of Dobbs, Chief Justice Roberts may recognize that it really is in the Supreme Court's own institutional legitimacy to adopt a code of conduct before one is forced on it.
We have a lot of important cases before the court. Surprisingly, Dahlia, we spent a lot of conversation going into Moore v. Harper, which was heard this year about gerrymandering in North Carolina, but that a lot of jurists and experts say has implications that are far greater than gerrymandering in North Carolina. It could actually determine elections and presidential elections in the future. The New York Times has been reporting, and others who have been listening to it say that the court seems split on that. There are three conservative justices who seem to be prepared to entertain some version of the independent state legislature theory, three progressive judges who will not, and then three whom we don't know enough about. And we don't know whether that means the case prevails or there's some compromise that comes out of it. Your thoughts?
I mean, based on listening to the arguments, Allie, which went on for 3 hours, it was a monster oral argument. I think it's fair to say that the things you and I talked about a few weeks ago when we previewed the case, the most maximalist, the most sort of big swing arguments were not going to find 5 votes. Not clear they were going to find 4. It seemed to me that those 3 justices sort of in the middle, Chief Justice John Roberts seems not at all interested in the independent state legislature doctrine or applying it the way North Carolina wants. It felt as though Justices Kavanaugh and Barrett were not interested, again, in the super nuclear version of it that was being floated by North Carolina. Whether they can find some principled middle way and what they rooted in, I think is the question. But for those of us who went in thinking Moore v. Harper is about to change voting as we know it for all time, I'm not sure that the court is really, really interested in doing that.
Jeff, Dahlia and I have had this conversation. Judge Michael Ludig and I have had this conversation. You actually introduced me to Judge Ludig. He's a conservative. A lot of people. This isn't entirely. In fact, it's not really partisan. It shouldn't be. It's looking like that on the Supreme Court, but it shouldn't be. There are a lot of conservatives who say this independent state legislature doctrine is a fringe interpretation of the Constitution.
There are indeed, and as Dahlia said, it looks like a majority of the court will agree. The maximalist position, as she identified it, didn't seem to get a majority on the court. That position would allow a legislature after the fact to change the result of an election. And instead, it is significant, as Dahlia said, that Justices Kavanaugh and Barrett were grappling toward a moderate solution. You could imagine Chief Justice Roberts embracing it too. If the court takes that moderate position, which basically says state courts can't completely change the law in dramatic ways when interpreting elections, but a federal court should be differential to their interpretations, that would be significant, but not a radical game changer of any kind, and would basically cabin in this extreme textualist interpretation that has little support in constitutional history and reach a more moderate result. It's interesting that the same dynamics seem to be going on in the recent case involving the web designer who didn't want to advertise weddings for gay couples. The maximalist position would say that any time a religious person wants an exemption from anti-discrimination laws, they should be able to take it. Here, once again, Justices Kavanaugh, Barrett, Roberts seem to be grappling toward this more moderate compromise that says web designers are special. They're artists, but they're not like limousine drivers or other professions, and therefore this is not going to drive a hole through anti-discrimination laws. And this is really the dynamic we're now seeing on the new Roberts Court. There are a couple of really significant cases, like the ones we've been describing, where there does seem to be this more moderate center emerging. By contrast, there are a series of really important cases, most notably affirmative action and the voting rights case that you mentioned, where we are likely to see a very strong 6-3 majority, totally polarized with little effort to find a compromise. That seems to be where we are in the early days of this term.
So you point out at least a couple of cases. There are actually a whole lot of important cases on the docket this season. Dahlia, what stands out to you? What's the one that, other than Moore v. Harper, that we're watching right now? What's the one that you're most interested in, worried about, happy about?
There's not much that I'm super happy about, to be candid. I will say I think Jeff checked off the big boxes. I think possibly the end of affirmative action in higher education, the Indian Child Welfare Act under assault, and real meaningful questions about whether that will survive. And just voting rights, gerrymandering, racial gerrymanders are all on the docket. I think I have said before, and I really do feel that almost everything that didn't get addressed last term is being addressed this term. There's not a lot left on the table between last term and this term. And I think that if we remember, at least I remember, and I think Jeff would agree, we used to have 2-3 blockbusters a year. Now we're looking at 6 or 7, including the Clean Water Act.
Yeah, so for those people who think Dobbs was the biggest thing, and it might well have been the biggest thing, there are a lot of really big things before the court. Jeff, your take on the ones, and I know you read all of them and all of the dissents, so you don't like to choose. But for my viewers, what should they be reading into?
Well, again, Dahlia identified the major cases, but viewers, as you're preparing to have these cases come down, do read the briefs in the affirmative action case, the voting rights case, the independent state legislature case, and this web designer case. And you can read the majority opinion, read the dissent, and make up your own mind. We're in the middle of a historic sea change in the law. And under the name of textualism, the court is overturning a huge number of precedents that go back to the New Deal era or before. Some of you will think it's correct, others will disagree, but it's really significant how we're going back to first principles like no other time since Dahlia and I have been covering the court, which is a very long time indeed. Remarkable times for the Supreme Court and very, very significant cases on the horizon. And
you are the two perfect people to have on this morning to help us understand it. And I know it's not easy reading. It's like giving people an extra helping of Brussels sprouts, but you might want to read these briefings about these cases because they're really important and they're really going to affect you and they're really going to affect the future of democracy in this country. Thanks to both of you. Jeffrey Rosen is the president and the CEO at the National Constitution Center. Dahlia Lithwick is the senior editor at Slate and the host of the Amicus podcast. She's also the author of the New York Times best-selling book, Lady Justice.